Good morning, everybody. You're all very welcome. There are still people joining. So we have a poll there on screen. I'm hoping as many of you as possible will take the 20 or so seconds it's going to take to fill it out. And we leave it up there for another 30 seconds or a minute or so. I'm very happy to welcome you all to our first webinar of 2022. It is the 9th of February. Some of us have started trickling back to the office. Some of us are working our way and ramping our way up to going back on a more sustained basis. It feels like only yesterday we were the 12th of March 2020 when the whole country went home. We packed up our laptops, we put our screens under our arms and we headed off into the distance. I found an email last week to one of my colleagues on the team about toilet paper because it's what we were all obsessed with at the time. And the fact that I thought it would be about 6 weeks before we'd be back in the office. Little did I know that almost 2 years later, we would all be still at home and only now actually returning on a part-time or on a full-time basis is becoming a reality. So for us, for the country, for our clients and for the whole world, remote working became a reality really, really quickly and with no notice. For many employees, it is here to stay, but for many employers in particular want their employees back on site, and some roles are simply not suitable for remote working on a sustained basis. And absolutely, there are pros and cons to remote working, and there are pros and cons to having employees back in the office on a sustained basis and on a full-time basis. So just around the time the government announced the fact that employers could start returning people back into the workplace on a phased basis, we put a poll up on LinkedIn, like maybe 2 weeks ago, a little bit over 2 weeks ago. It's a little bit of surprise at the results because at that point in time, 38% of the people who responded to our poll on LinkedIn said that they were already back in the office. 33% actually, which was lower than I expected it to be, said they had no plans to return. Bear in mind that this went up probably a day or two before the government announcement. 10% said they would start phasing people back in from March, or they're hoping to get people back in March. And then the balance, which was 18%, said they were going to start bringing people back in from February. So I think the reality is that most organizations, and certainly most of the employers that we're working with, and the view is that some sort of remote working is here to stay, whether that's full-time for some people, whether it's hybrid, sometimes remote, sometimes in the office. And I think it's part of our language. It's part of most organizations' culture. Like I said, there are pros and cons to it. Today, we're not going to look at the pros and cons. We're going to look at the legal issues. And what we're going to try and do is go through the questions that we've been asked most. So there are 25 lawyers on the team now, and we feel that the kinds of things that we're getting asked to advise on, the kinds of questions our clients are raising with us, with the team, are a fairly good measure of the kinds of things that are issues for most employers. So 3 parts to what we are going to cover. The first is kind of the general government strategy and the new draft legislation. The second piece then is the impact on the contract of employment. And then the third piece is something that we've been flagging as an issue from the very beginning, and that's the health and safety piece. There is a Q&A box at the bottom of your screens. Please put your questions into it. I'm hoping that by the end of what we're about to do, we'll have answered some of them, but I expect there will be other questions and issues that some of you have that you'd like us to just work through, and we will get through as many of those as we can towards the end. I'm hoping we've about 10 or 15 minutes to get through them. So I'm going to start. And I suppose just to kind of for setting the scene, you will all remember the government strategy on national remote working that issued in January 2021. And Leo Varadkar, as the Minister for Enterprise, has been very vocal on, trying to set up hubs in areas in particular outside of Dublin. He then published the Code of Practice on the Right to Disconnect on the 1st of April 2021. And then 25th of January, fairly much in line with what he said he was going to do, a couple of months later, he published the scheme on the right to request remote working. Now, it's not a right to remote work, it is a right to request remote working. We have a new person joining our top tips panel today, Jessica Bielenberg, who you can all hopefully see by now. Jessica joined us about a year ago. Interestingly, for Jessica, she's been working remotely since she started. She hasn't even seen the office yet, except what I think I showed her one day on a Zoom. So hopefully Jessica's looking forward to coming in and seeing her workspace in the very near future. But I'm going to turn to Jessica first to talk us through this draft scheme for the new legislation around the right to request remote working. Jessica, tell us, what does it say?
So, as you said, yes, the Department of Enterprise, Trade and Employment published the general scheme of the Right to Request Remote Working Bill 2022. As it stands, employees don't have the legal or statutory right to request remote working. We've always been able, or employees have always been able to ask their employer if they can work remotely, but there's been no statutory framework around how those requests are made and how they are dealt with by employers. So that's what the Right to Request Remote Working Bill is trying to legislate for. So first of all, the bill or the draft scheme says that employees are required to have 26 weeks of continuous service with their employer before they're eligible to even put in a request to remote work. Now, you can agree a shorter time frame with your employer, but that's what the legislation is saying. To put in a request, then the employee has to provide certain details. They have to put in information about the proposed remote work location, the proposed start date, the number and timing of working days to be worked remotely. They have to complete a self-assessment of the suitability of the proposed remote work location. Once they put that request in, an employer is obliged to put in a decision within 12 weeks of receiving the request. So they have to consult with the employee or the trade union, and then they just decide whether or not to accept the request. They can wholly accept it, partially accept it, or they can refuse it. I think one of the reasons it seems to have landed, the draft legislation seems to have landed so badly with employees and their representatives, is the very wide range of reasons that is set out in the legislation for refusing a request. So the legislation sets out 13 grounds, and these grounds, they're non-exhaustive. They're indicative only, and employers can come up with their own reason for refusing a request. So I think the critics think it gives employers too much of an opportunity to say no.
And just to be clear, Jessica, it's not legislation yet. This is the draft scheme. So it hasn't been implemented, scheme. But this is what it says. Yeah.
So employees have to wait. They can put in a request. They have to wait 12 months before putting in another request. The request can be withdrawn under certain circumstances if they fail to provide their employer with additional documentation, or they don't meet with their employer to discuss the request. There's also, as expected, anti-penalisation provisions, which would, so that employees aren't penalised for exercising their rights under the legislation.
So Jessica, it is a kind of, it does what it says on the tin, right? It's a right to request remote working subject to certain time periods. There's an obligation on the employer to consider it and to give reasons for their refusal. There is, as you say, a non-exhaustive list of potential reasons. But say an employer comes up with another reason, like, I don't know, something very woolly, just because I think it's important for team culture and learning by osmosis. That's my big one, learning by osmosis. I want you back in the office and I want you here 5 days a week. What can, if anything, can a disgruntled employee do then if they're unhappy with either the lack of response or the substance of the response?
There's in reality not much they can do. They can put in an appeal, and employers should have an appeal process in place in their remote work policy. And an employee has to wait 2 weeks to allow the employer to deal with that appeal. There is then a right of appeal to the WRC, but as it's drafted, it's procedural only. So as it's currently drafted, you can't appeal based on the grounds that the employer has refused your request on. So in those respects, I think it's been reported in the media to be called a bit of a toothless tiger or a damp squib, because there's no imperative on an employer to agree to their request. All they have to do is respond within a specified time frame, give a specified reason, and that's their obligations complied with.
So if I'm unhappy with the reason, or if an employee is unhappy with the reason, there's really nothing they can do.
As it stands. And Leo Varadkar has said that this is a draft scheme and that it will be subject to change. And I think he's reported in the media saying that there will be a way for an employee to challenge the validity of the ground. But I think that remains to be seen. And as drafted, it's procedural only.
And Jessica, this is all then part of the government strategy around remote working. Part of that strategy was to issue the code of practice around the right to disconnect in April 2021, so nearly a year ago. Where do the two sit together, or do you have a view on that? The right to the code of practice on the right to disconnect, and then the right to request remote working.
Yeah, I think it's tricky. The right to disconnect came in to really remind employees and employers that employees don't have to respond to emails immediately and don't have to routinely do work outside of their normal working hours. And as we're all working at home more, I think the accessibility of work became different in terms of how we did it, when we did it, and where we did it. And the right to disconnect was to remind you that there should be, I suppose, a boundary between your personal life and your professional life. But the difficulty is, I think there's a real appetite for employees to have this flexible working and this remote working, and that, with your employer's agreement that you can, do the kids' homework for an hour or go to the gym in the afternoon and then jump back on to work in the evening. But that doesn't really align with the right to disconnect, because that's saying you shouldn't be doing any work outside of your normal working hours. So I think it's not a one size fits all approach, and how they kind of work together is difficult to see.
And I think you make a good point there. Remote working is not the same as flexible working. No. And just because an employer might decide to facilitate remote working, that doesn't mean, as you say, doing an hour's worth of homework with the kids or nipping out to the supermarket when it's not crazy. They're actually two different things, and they shouldn't be confused.
Completely different things. Remote working is just where you're doing the work from, and you still have your normal working hours, and a flexible arrangement with your employer is something completely different that you would enter into with them.
Yeah, absolutely. Jerry, I want to talk to you now, because there's the government strategy, there's the code of practice on the right to disconnect, there's now this new draft legislation around remote working. But if you pedal backwards, every employer has a statutory obligation to give certain information to employees in writing. That information is usually packaged up in a contract of employment. Not always, sometimes it's a very bare statement of terms and conditions. And one of the very basic things an employer has an obligation, a statutory obligation to give, is details of the employee's place of work. And for you and for me and for Jessica, that's in the Mason Hayes and Curran contract of employment as South Bank House, Barrow Street, Dublin 4. So there's this, most employers, and we all live in the real world, so we know not every employer has written contracts, but most employers, the most good employers, have written contracts and should have written contracts which state the place of work to be X, South Bank House, Barrow Street. And now we've people working from, Galway, Cork, Limerick, Clontarf, Swords, Donnybrook, Foxrock, wherever, Dunleary, and there's a disconnect there, isn't there? Where does this whole right to request remote working and employers facilitate remote working, where does that sit in relation to the contract of employment?
Yeah, I think the important point is that your contract of employment is still valid, and the location of where you do your job is still valid. And I think there's been a train of thought, because there's lots of social media about the Great Resignation, which is driven by effectively the employer not allowing the employee to do their job remotely, or that if you want to bring me back from Roscommon to Dublin, I'm just simply not going to do it. But fundamentally, the contract that you had before the pandemic started, which set out your place of work, is still valid. And it's important about the right to disconnect is, firstly, it's a code. So it's actually, it's the height of it is that you should follow the code. The right to request remote working, it's going to be better than a code, but to my mind, it is, if you want to call it, the outline of a request or a debate to have a discussion in relation to what is the contractual provision, and the contractual provision being that you will still do your job. And if you boil it down to one of the fundamental questions we are asked is that, can I say to someone, I think you should do your job in the office? The answer is yes, and you will still be referring to, well, this is what's in your contract of employment. Yes, we can go through, and when it becomes an act, we will go through the various processes about how you can request remote working and things like that. But fundamentally, an employer has not lost its right to ask an employee to attend the office.
Yeah. And if an employer, Ger, decides to facilitate some element of remote working, should they change the employee's contract of employment? Does it need a formal amendment? Should there, be a policy? What's your recommendation?
Yeah, well, I think we should. Remote working is here. Okay, so I think one of the things we all acknowledge that whatever you want to call it, hybrid office / remote working, it is here to stay in the long run. And I think what is the benefit of the last 2 years, we now know that a lot of jobs which we were maybe unsure of can be done remotely, or certainly there are certainly benefits to the hybrid model. I do not recommend that you issue brand new contracts of employment, because depending on the size of your organization, it might take you a full year to just actually get around to doing that. But what we are recommending is that you should absolutely have a policy that sets out what is your organization's position in relation to remote working. And it's important that people now, before the legislation comes in, they should concentrate on what this actually means for them from an operational point of view, and what is actually their preference. Because unlike other policies, when you look at handbooks, and handbooks have absolutely ballooned in size in the last few years, a lot of policies and handbooks become an issue when there is an issue in the workplace, such as disciplinary, grievance, sick leave. But actually, when you strip this back, is your remote working policy is going to probably have a bearing on your employees' performance of their job on a weekly basis. So 2 days of the week, the policy that is the remote working policy will be what the employee is actually working with. And then you may have the other days, you have your more standard contractual arrangements. We believe, and our strong advice is that, one, you need to spend time getting your remote working policy that suits your needs, but it does interact with your contract. Your contract and remote working policy will actually become a very much joined up document, and it should be seen as such. If there is very bespoke arrangements, if you are a huge company that has 2,000 employees, you're of course going to have a baseline, and a baseline is going to set out what your policy. But if you're having very bespoke arrangements, I don't think you don't need to have a formal document, but an exchange of emails about what we're working towards is prudent and practical, because the last thing you want is to go to a WRC and there is a dispute over the fundamental terms of what was agreed, be it over coffee in the kitchen or just simply custom and practice is such an overused term in employment law, but people sometimes see if it happened for 2 weeks in a row, well, now custom and practice is kicked in, right? When it's not. But so our advice is that if you obviously have a policy that has a standard, or what is your standard kind of remote working terms, but if you're going with very bespoke arrangements, committing an email where both sides agree to them, it will benefit you in the long run.
And just to add to that, make sure it's very clear that the employer reserves the right to change the arrangements and review them from time to time, because ultimately the contractual place of work is South Bank House, Paris.
Right. Absolutely.
Yeah. Jessica, I want to bring you back in there just for a second, because the draft scheme of the new legislation mentions policies as well. What does it say?
It's under the draft legislation, employers, as Ger said, will be required to have a remote working policy in place, and actually could be fined if they don't. Up to 2,500 is mentioned in the draft legislation. So all employers now should be looking, if you don't have one already, you should be looking at the legislation and thinking about it. But again, it is a draft scheme. It is subject to change. So there may be some amendments before it's finally.
I think it's interesting that the legislation provides that it's, you know, as you say, for a fine, like it's an offence, it will be an offence not to have one, which is kind of unusual for employment legislation. We have offences in some employment permits, work permits legislation, but to put it in here, I think it was an interesting choice. Ger, I'm going to come back to you, and I want to talk to you about, you know, protecting confidential information, data privacy, and all those kind of things. But before I do, one of the big concerns amongst our clients is what to do if an employee refuses to return to work. And there are a whole lot of reasons for that. I'm nervous. I've bought a house in Roscommon. I moved down to Wicklow. I don't want to commute. I'm doing fine. You know, and you've been very clear there. The contractual place of work is the contractual place of work, South Bank House, Barrow Street for us. But what can an employer do, or what should they do if the employee is point blank refusing to come back? And like I said, there's two reasons for that. There might be just, I don't want to come back. I've moved. I've changed my domestic arrangements. And then there's also the nervousness piece. So some people, you know, I have asthma, I have underlying conditions, I'm still worried about COVID. I think that's a separate piece, and we'll come back to that in a second. But just park that I'm worried, I have underlying conditions, park that, just I don't want to come back for whatever reason. What can an employer do about it?
Look, I suppose for the purpose of the answer, let's go and assume that we've worked through kind of the true reasons, you know, am I sick? You know, but I think if you look at, say, someone who says, I am really happy working in Roscommon, and they might say, I actually think I'm even more productive in Roscommon because I don't have I have no commute and have no distractions. It's clear that we're all waiting for the case where the employer basically says, you have to come to the office on Monday, failing which I'm either going to discipline you for failure to follow a reasonable request, or in a very dramatic, and I wouldn't recommend this, Melanie, have you resigned from your employment? Because at some stage we're going to have to kind of solve the debate over who has the power in the relationship. You know, we say, well, if the contract says your place of work is in Dublin, well, the employer has stipulated that from the very outset of the relationship, and the contract could be years old at this stage, where you have a simple refusal. I mean, that's just the simple refusal is no more than it no longer suits me. It will be interesting to see, will there be a kind of a thread of case law where it basically says, I can't go because I don't have childcare arrangements, or my childcare arrangement is much limited in terms of the hours of availability, and where you have these direct and indirect discrimination cases. And the one thing, we see this more in high court cases or more civil court cases than if you call it WRC. The courts are, and maybe they will be, reluctant to get involved in the controlling the employment relationship. You know, that is, the preference should be with the employer of where to do the work, as opposed to effectively having a debate. But we may ultimately get to the case where a person is deemed to have either resigned from their employment, or B, outright disciplined through the disciplinary procedure for what the employer would hold out as the failure to follow a reasonable instruction.
Yeah, and breach contract.
Right.
I'm delighted to see there's lots of questions rolling in, and some of them I think we will get covered as we go along. But on there's one obvious one there, Jessica, and I wanted to ask you about it because I think the draft scheme of legislation touches on it, and that is, you know, remote working from where? Remote working from, you know, Greystones versus remote working from Roscommon versus remote working from Mammy's house in Madrid because I've gone home, or Brazil. And then there's remote working from Starbucks, right? I went into an insomnia last Monday, and like I was half surprised to see half of insomnia tables filled with people on their laptops, like thinking in my head, half thinking, geez, that's a great idea. You have coffee on tap. And then thinking, no, I couldn't. It was cold apart from anything else. I couldn't do this. But where, like, does the legislation touch on that, Jessica?
Well, one of the grounds that an employer can refuse a request to work remotely is the suitability of the proposed location from a health and safety perspective. So
the employee has to specify Roscommon, Greystones,
yes,
Madrid, Starbucks.
In their request, it's one of the details they have to include is the proposed remote working location. And they also have to do that self-assessment as to the suitability of that proposed remote working location.
So a permission to work remotely is permission to work in a specified place, exactly, and not necessarily the summer house in Spain, the mobile home in Lahinch, or Starbucks.
Yeah, or to constantly be moving around.
Because the Starbucks, Jared, thing throws up another concern amongst many of our clients, and a general concern, and that's around kind of confidentiality. So it's much harder for employers to manage confidential information. They can't control what's being printed out, who can see whose screen, are there two people at the kitchen table, or is somebody in Starbucks? Oh, like that confidentiality piece is a concern, isn't it?
Huge. There was a survey done at the middle of last year where 85% of employers, so you're as close to 100%, are more worried about their confidential information than ever now. And the reason being is that your confidential, your Starbucks, your Wi-Fi, you're just what's people coming into your house, and you're working at your kitchen table and you have the documents. A lot of offices log what's being printed, but they don't log what's being printed at home and things like that. And it's interesting that your obligations to protect confidential information remains the same. And we have seen in a lot of policies where this has been inserted merely to remind people of their obligations. Lock your computer, put things away, and it's kind of like the basics. And even the Data Protection Commissioner has said, issued a kind of, and it was March 2020, but it's nothing new. There's no new data protection law. There's no new confidentiality law. It's just basically a reminder of the basics of, if you log into an open Wi-Fi network in Starbucks, it is an open Wi-Fi network. You're meant to keep personal data. We all heard cases of them years ago where the laptop got lost in the train and it contained everyone's personal information and things like that. So the same obligations exist. It is interesting that we are seeing maybe cases where removal of confidential information, or this concern about confidential information, is a concern in that people are fearful that when people resign and leave, that they have removed things that would help them in there, and have removed and have printed documents. And this is a reality. And I think the height of what you can do is reinforce on a constant basis the ongoing obligation to A, confidential information has to be kept confidential, and B, to Jessica's point about where you're going to carry out your work has to be carried out from wherever you want to designate it from. And it can't be this very fluid arrangement of a week in Spain, a bit in Starbucks, and a bit at home.
And it's kind of related, but I have a slightly different question for you, because those concerns around confidentiality steep into concerns about the protection of personal data that might be on people's laptops or phones or whatever. But there's also the other piece around monitoring of employees who are at home. Is there a greater level of, the Big Brother type monitoring of the Microsoft Teams thing there, where it goes red when you haven't been on your keyboard for 15 minutes and all of those kind of things? Data privacy, is that an issue?
It's an interesting point, because this has been suggested to me recently, and I disagree with the point in that most policies will say that the employer reserves the right to, look at emails and monitor emails and email traffic and all things that from your policy. And one person has said to me, or has been argued, that by virtue of working remotely, it gives the employer, or the employer has, if you want, a more just reason, and it's proportionate to spend more time looking through emails to see what is being printed and not being printed. I fundamentally disagree with that because there is no basis for that. The Data Protection Commissioner has not said increased surveillance on online shopping and, things about, how often the mouse moves, how often emails are being sent. There has been no issuing of any guidance in relation to that. So we're back to where we always were, in that an employer, provided they had the right, could always monitor emails and email traffic, whereas reasonable proportion. If an employer had a reasonable belief that something wrongdoing is happening, well, yes, some employers do step up the level of, but I think the idea of I'm going to sit and have a huge, gathering of data over a person's usage at home in terms of logging on, logging off, that is not permitted. There's been no guidance to say, yes, you're permitted to inspect and monitor people more because they're at home as opposed to in the office.
And you saw that this week, Jared, didn't you, when a client could see that somebody was printing off reams and reams and reams of confidential documentation, but actually the fact that that person was at home at their kitchen table or wherever they were, desk in the bedroom, under the stairs, didn't actually make any difference, because that checking of the printing of confidential data is justified whether the person's doing it from the laptop on the printer at the end of the office or the one at home.
Correct. And it goes back to, actually, there was an interesting point in that situation, is that there was mass confusion, not on the employer side, but certainly sometimes on the employee side, is what is confidential information. And sometimes people believe that if I work on something and contribute to it, well, that's just my information, as opposed to, and sometimes you're stripping it back to the basics. If you are performing work for your employer, no, it's their confidential information, and it's not your decision to render what something's confidential or not. But in the case itself, yeah, a lot of stuff was being printed off on the system. We could see a lot of stuff being searched for and things like that. And it just shows you that maybe employees are braver because I'm in my living room and I'm hitting print, as opposed, and the chances of, if you're printing at 10 o'clock at night, no one's going to come across and see, there's no chance of it being left on the printer incorrectly, because it's going to be your own printer. But it goes back to probably the fundamentals of, this concern existed 2 years ago, but the problem is now is, I suppose, where the person is accessing it by virtue of the VPNs, the ability to print, and the ability to, we see things where people get very sophisticated. They actually just take pictures on their iPhones of the information as well. But this can happen in the place of work and at home. But I think there's an element of, my top tip would be to remind people about what these obligations are. So, not that I'm watching you, but that confidential information must be stored, and it can't simply be removed, particularly where I think there's a fear that there will be a higher turnover of staff than ever in all businesses due to, if you want to call it, personal circumstances. So there probably the temptation to assist you in the next job has never been as great.
I want to shift the focus slightly, Ger, and Jessica mentioned this when she was talking through the new draft scheme. Under the scheme, when it is implemented and when the legislation's passed, we expect there will be a requirement for an employee to submit with their application for remote working an assessment of the workspace. So they're going to have to nominate a space, whether it's the kitchen table or the desk in the bedroom, or some people are lucky enough to have a study. Other people are working at desks under the stairs or in the hallway or whatever. But one of the things that we've been flagging to employers since the very, very beginning, and we did a couple of top tip sessions on it, is the whole health and safety piece of employers facilitating remote working and people working from home, because that's been an issue since the 12th of March. 2020, when everybody went home under the instructions of Mr. Varadkar from Washington. Talk to us generally about health and safety, the remote working aside, but health and safety obligations of an employer under the legislation, which dates back to 2005 and is very onerous.
Very onerous. And I think the fundamental thing that we have to appreciate is that if you are performing work, the same obligation applies if you're performing work in your office as it does at home. So there is no distinction. The legislation does not say, and by the way, you have a lesser obligation when the work is being performed in your bedroom. So and from the kitchen table. And I think so that's the first thing that we must say. The second thing is that, and I think some employers have been better than others in that you have to ensure that your employees have the right equipment and the right setup. Now, obviously, you can't rent rooms for them, but obviously desks, seats, and allegedly that doctors and GPs are seeing a lot more soft tissue damages, carpal tunnels, because people are sitting at the edge of beds, doing on at the kitchen table where they don't have the right equipment. So your obligation is onerous. Is that have you provided the employee with the right setup to perform the duties? And where this will come to the fore, and now we haven't seen it in Ireland, but we have seen it in the US, and we saw it in Germany in December, where a gentleman, unfortunately, he was walking down the stairs and it was a spiral staircase down to his office. He fell and broke his back. And there was a case in Germany, which was to do in Germany, social security, whether it was a place of work. And the German court held that he was at a place of work and is therefore covered by the compensation scheme. So you can see firsthand how your home can become a place of work. And the same trend has happened in the US as well, where they have the concept of workers' compensation scheme. The employee in the US, it was in Chicago, was also deemed that their accident at home was a place of work and therefore fell within the scheme. Now, there are very bespoke questions about, if you want to call it, insurance policies and social securities, but it is showing a trend of where we are heading towards, is that if you have permanent remote working, the idea that you can avoid, you have no responsibility to how the employee performs the work, I think is wrong. And it is not in line with the legislation, as you said, which was introduced in 2005.
And the legislation is very clear. It says the place of work is anywhere from which the employee works, and that it's very clear onus on employers to conduct a risk assessment and have a safety statement. And that's something we've been saying over and over again to employers on these webinars: do a risk assessment. And, strictly speaking, they should be physically done. They should include the steps up to the front door, the stairs, the heating, the windows, the whole shooting gallery. We've settled for something shy of that because it's reasonable in the circumstances, although not perfectly in compliance with the health and safety legislation. But there's lots of questions coming in here. And one of the ones that I can see coming up a few times, Ger, is whether it's possible to insure employees, or, whether it should be, the employer, a little bit like, when I drive my car for Mason Hayes and Curran business, I have it noted on my car driver insurance policy that I'm using it for work. So what, and this isn't something that we were planning on covering today, but I do think in the context of what you're saying, it's an interesting question. What's your recommendation around kind of what can an employer do to insure against the lad falling down the stairs, the spiral stairs?
I think you need to at least you have to take positive steps. You do not have to have, you're not required to set everyone up with a beautiful office. But I think you have to see, like, the legislation, it has to, to comply with the legislation, you must be making what would see as reasonable efforts. What's reasonable efforts? We all see on Zoom calls if someone's sitting on the edge of a bed. So we all can see what people's setup is now more than ever. And I think, ensuring that the person has the right.
The blur, though, Ger. We've discovered the blur. We're loving the blur.
Exactly. So I think you have to ensure the person has the right equipment. I think there's so much online now. I've seen this done firsthand, you know, online ergonomics of what's your setup and stuff. We see this built into contracts, you know, the employer reserving the right to inspect the person's house. You know, Melanie, I'll be around tomorrow to have a look with my measuring tape and all things like that. And they are embedded in policies. But because of COVID, no one's coming into your house and things like that. But I think if you are trying to, we represent more employers than employees. If you are defending a case, what is your defense going to be? If it is, you knew that you knew my setup was all wrong. You knew I was surrounded by boxes. In fact, you were sending, in the case in Chicago, they were sending the boxes out to the person's house to pack. So they knew exactly what the issues were. I think you would have to have one, that you have at least self-assess the employee for equipment. And also, I think, you know, online, some sort of, you know, health and safety, be it online self-assessment, done through a Zoom call. I think it's slightly unrealistic as of today for the health and safety person coming out and saying your steps up to your house are a bit steep. But I think there is, I think you have to have a reasonable defense, and you must be proactive. I think those who simply, as an employer, choose to ignore and say, it's okay because no one has said anything for me for the last 2 years. I think those are the employers I would have concerns about in the long term.
I think it's interesting too that it's, and Jessica flagged it there, that it's in the draft scheme for the new legislation, the requirement for the employee to identify a place and do it and do an assessment themselves. Like it's actually at odds kind of with what the health and safety legislation says. But if I say, you know, dear managing partner of Mason Hayes & Curran, this is my workspace. Here's the photographs. Here's my chair. Here's my desk. And then I don't know, scold myself on the kettle downstairs or trip over on my way into, you know, some Starbucks and impale myself on my laptop, because that's not the place of work that I'd identified as my remote place of work. Will that make it then easier for employers who are trying to defend the inevitable personal injury claims because I'm not at the place I identified? It certainly narrows it.
It narrows it, but it raised an interesting point in the case in Germany where the chap fell and down the stairs. He was on his way to the office and he deemed that the argument was, what did that amount to? And actually it was deemed his commute. We all joke about I have a short commute now from my bedroom to my office and things like that. But actually, that's what it was deemed. It was deemed one of the fundamental arguments was about what, because he was on his way. He was actually on his way to start work when it happened. But you can see how these claims will become, I suppose, interesting from a legal point of view. But at the end of the day, you have an injured employee who was either on a break from work or doing something, or more importantly, was maybe working for you. And who's responsible for that liability?
There are an absolute larry load of questions here, and I'm going to try and get through some of them. First one up for you, Jessica. And this is something we've seen, not lots of, but actually a little bit. And that is employers who've actually shut their workspaces and shut their offices and stopped paying the rent. So question for you, Jessica, can employers force employees to work from home?
In general terms, no, you can't force an employee to work from home because, again, going back to what Ger was saying, if your contract of employment says that your location of work is the company's work premises, that's a core contractual term. And to change that, you need the employee's agreement. So you need to consult with them, reach some kind of agreement with them. And failing that, if you can't, and if you actually don't have any physical office space left, well, then you may be looking at some kind of redundancy situation, depending on the circumstances.
And then back to you, Ger, and this is something we actually did almost a full webinar on it specifically, and that is, we touched on a little bit earlier, the working from home for Roscommon, Limerick, Galway, but there's a couple of questions in here. What about somebody working from home in Northern Ireland? It's a different jurisdiction, isn't even in the European Union anymore. And that's the one thing. So they declare it, I'm working from Madrid or whatever. And then there's the other part of that, which somebody says, I'm working from home, I'm in Clontarf, I'm in Swords, I'm in Greystones, but they're actually in Spain. And you can see the sun beating down through the window outside.
Jessica, the sun behind Jessica.
Actually, well, and there's a full-on misrepresentation with one, but then there's the other piece, like I'm working from home. And this has been an issue for lots of employers and big issue for lots of the tech companies in particular, employees working from home who've actually moved to another jurisdiction, because that gives rise to a whole host of issues, Jeff.
It gives rise to employment issues may be only one part or the lesser of your problems, but
because like, just to be clear, because they very quickly become entitled to protection of the local employment
correct law. So what normally it's a good idea to kind of go with the concept of where you're living, you're getting the employment rights within that country. So if you move to, let's go to Spain, after a while you will get Spanish employment rights by virtue of living there. And what may happen is, through your own generosity, as in the Irish company's generosity, you might end up being sued in Spain, and then all of a sudden you have been sued in multiple jurisdictions. So your generosity will come back to bite you maybe at a later stage. You also run into various other problems which have to be all teased out. Is you also run into a taxation problem. The person is no longer tax resident in Ireland. So are you paying the wages correctly? I have come across a case this week where people no longer want to pay PRSI contributions in Ireland because they're not living in Ireland. They want to pay the Spanish ones because that gives them their kind of health protection. You have concerns at a wider, much more serious level about, has the company inadvertently created a permanent tax residence in another country, that affects its whole structure. So I think one of the things of these, and I think this is where it's going to trend, because people were very relaxed and generous about people moving home. So people would have if you want to call it family support during, because lockdown, we all know can be extremely lonely if you're by yourself. But you do have to wonder, as we progress from this remote working, will you actually see people being asked to come back, and it being driven by a number of reasons? One, the concern of the employer about, I don't want to get sued in France because it's not a great place to get sued, and this is causing me such an administrative and taxation issue. I'm going back to the old school of, will you come back into the office and all under one roof?
And we saw this not December 2021. We saw it December 2020, by which point lots of organizations had employees who were working from different jurisdictions for well over 6 months, and there was lots of press. December 2020. March or January 2021. So we're talking well over 12 months ago, where the tech companies in particular said, you got to come back. You got to come back into the jurisdiction, not helped by the fact the whole country went into lockdown just after Christmas, if you all remember. And the travel piece became difficult, but they were very clear in issuing instructions to employees who'd gone to different jurisdictions to come back for exactly all of those reasons: local employment laws, permanent establishment tax risks, social security, income tax, all of that. And you have to come back to Ireland, even though our offices aren't open, but you have to be in Ireland for all of these reasons. And they did it with some success, actually, and probably some dismissals along the way. Well, definitely, because I know I was involved in some of them. And an interesting other issue where some employers who did have companies or local entities in some of the countries and said, right, Jessica, you can stay in Milan, but you need to go on an Italian contract of employment and be employed by the Italian entity. And then Jessica was like, well, no, because my grade initially gets me €20,000 a year less. So there was all of that. But it is actually something to watch. And if employers have employees who are still working from a different jurisdiction, all of those issues need to be considered and teased out. Or if you decide the cost of even doing that is disproportionate, then just an instruction for them to come back to the country / back to the office.
Yeah, and it's interesting. One thing I've seen probably in the last 3 or 4 months, as if it's the solution, and it's not the solution, is that the employee becomes a contractor in that country. So you have this person all of a sudden is now a contractor in Cyprus, a contractor So you kind of say, well, I'm going to contract now and it's going to reduce my liability. It doesn't reduce I'm on strong view, it doesn't reduce your liability. You're just dressing it up as something else. And so while the temptation is, of course, let's rebrand it and repaper them as something else, it's not the workaround for the issue.
Jessica, I want to turn to you now and a couple of kind of related questions. And the first one's come up repeatedly, which is if I'm going to when, because it's not going to be an if, assuming the legislation isn't going to change drastically, when I implement my remote working policy as an employer, can I have different arrangements for different sections of the workforce, for different levels of the workforce, for different types of employees?
I think that will all depend on what it says in your remote working policy. But
that's the question. Can my remote working policy say, if you are a junior X, you've got to be in the office 5 days a week, but if you're grade 6 or above, you only have to come in 2 days? That's the question.
Yeah, it all has to be agreed between the employer and the employee, and the legislation as it's drafted is all stacked in favor, as far as I can see, in favor of the employer. So yes, the employer can have any of those arrangements in place.
So there's the policy and then there's the individual arrangements, but the policy documents, just so we're clear, can say for particular grades of particular roles, this is the arrangement and it's different for others. Is there a discrimination risk with that? And I've flagged this in the press as well. I have a concern that lots of the people looking for remote working or working from home will be female, will be mammies. Is this going to turn into a gender issue?
I think it has the potential to do that, because it tends to be still the female in the home that is the kind of primary caregiver, whether for children or for parents. So you have elderly people as well. So I think it could turn into a gender issue, and I think that's all remains to be seen as to how many requests you get in, how it's dealt with, how employees feel. Because if they see that Jane from, down in the office is getting remote working 3 days a week and you've asked for it and you've been refused it, employers are going to have to be able to set out the grounds as to why they've refused you and yet they've let Jane have it 3 days a week. So it could cause a lot of employee relations difficulties, I think, and then as well, potentially gender discrimination.
Yeah. And actually that is one of the questions. If we agree something for one person, do we have to mirror it? No, but you need to be able to justify it.
Exactly. No, but it could cause employee relations difficulties within the office, I think.
And it's interesting, Ger, the question about people working outside of Ireland and refusing to come back or else not disclosing it keeps coming up as well. But your advice has been invoke your disciplinary process if they fail to if they misrepresent something or if they fail to disclose, if they refuse to return.
Exactly. Well, we've had these cases where people have discovered that the person has moved to Spain, to Poland, because obviously, Zoom calls can hide a lot. If it's in a dark, if it's just the blank wall behind you, it's to do with your disciplinary. It's did you agree to it? And there's nothing wrong with asking the person to come back to Ireland. It may ultimately end an employment relationship, but there's nothing wrong with it.
And Jessica, 2 more questions for you then. What about an employee who says, I've let my nanny go, or I don't want to send the kids back to creche, and so I don't want to come back? Does an employer have to agree to that? No,
I mean, the employer doesn't have to agree to any of that. I think what employers might find that if they take too hard a line, or if they're too rigid in their decision making, employees ultimately will possibly vote with their feet and move on. And maybe employers who take that hard line will find it difficult to attract talent or retain talent. But there's no obligation on them. If the workspace is, if it's in your contract of employment that your workplace is the office, that's your workplace. And ultimately an employer can just say, no, we want you back in this specified work location, and then they're just taking their chances on whether employees will stay with them or move on to some other employer who's more flexible in their outlook.
And then final question, Jessica, what about somebody, and we've all seen this and we've been seeing this since the very beginning, I don't want to come back because I have asthma or I'm immunocompromised, so I want to continue working from home. What does an employer do in that situation?
In that situation, I think an employer should be getting them assessed in the first instance. I know the transitional protocol, which is kind of the updated work safety protocol, which was released recently or published recently, it divides workers into high risk, very high risk, or high risk. So if you have a worker that comes into one of those categories and they're raising issues about returning to the workplace for health reasons or for, they're concerned about their safety, you should have some kind of fitness for work risk assessment with their medical advisor and in consultation with the employee.
So medical issue, health and safety, right, the two of those. Sinead, you might put up the results of the poll we ran at the beginning of the session there. We'd over 150 responses to this, so it's great. So has your organization started bringing people back on site? Just over 50% said yes, 13% no, and 36% is partially. I think that's where we sit. We sit on the partially piece. We're ramping back up. Does your organization already have a right to disconnect policy? Remember, this is the one where there's a code of practice. So it's not a statutory obligation to have one. 61% saying no. Yeah, I think that's about right. I think it was announced with a big fanfare. But again, a bit of a damn squib. Does your organization already have a remote working policy? And 59% of respondents said yes. That's interesting. We had actually introduced ones ourselves pre-COVID in Mason Hayes and Curran in response to just kind of all of the requests that we were getting. Will we revisit it now? I think yes, we'll have to, and it will be adapted. And I think if you take nothing away from this, it'll be important to reserve the right to revisit individual arrangements, collective arrangements, the policy, and keep it all under review. This is my big bugbear. Has your organization conducted risk assessment of employees' remote working spaces? 40% of respondents said no. I think that's huge, given that people have been at home for over 2 years. For almost 2 years. And I think that does present a risk for those organizations who haven't done it. And as Ger says, even if it's not the full belt and braces compliance with the legislation, to do something to mitigate exposure in the event something happens in the employee's workspace. That's an interesting stat. I'm a little bit surprised about that one. And how flexible will your organization be about facilitating remote working? Very partially and not at all. Yeah, so 5%, that's kind of where I expected that to be. I think whatever about organizations' views for recruitment, for retention, I think this is something that we're going to all be living with for the future, actually, irrespective of our own organization's views on it. I want to finish by just asking Ger and Jessica for their kind of top takeaways, top tips from each of them. But before I do, I just want to remind everybody that a survey monkey will come up on your screen when we finish. If you've any feedback, if you've any suggestions for topics that you would like us to cover in our next webinar, please plug them in there, because that's how we decided how to do this particular subject. And that's how we choose all of our subjects for our webinars. We try and, respond to where there's a demand and where there's a desire. So please use the Survey Monkey. Ger, Jessica, and Sinead and the events team, thank you very much. Hopefully the next one will be private and we'll get to plan our high heels again. Ger, 2 top tips from you for takeaways for our audience today.
I think tip number 1 is you have to comply with your health and safety obligations. And there's a stark result there. 40% of people have not done anything. So there's 40% of people in gross defaults. I think that's the first. The second thing is more kind of your confidential information is probably vulnerable by remote working. There's very little you can do, but as a very good starting point is remind people of what is confidential information and the ongoing obligation that they should act in a prudent manner when it's in their house, close down their laptops, what they're printing, and the destruction of things, such as will you bring the stuff back into the office to be shredded as opposed to be put into your green bin? So I think there's the two takeaways.
So remember your confidential information and do what you can to protect it, and be very conscious of your health and safety obligations, statutory health and safety obligations, conduct your risk assessments. Jessica, 2 final tips from you.
I think the first one has to be, if you don't have a remote working policy already in place, or if you have one, review it. And if you don't have one, start thinking about putting one in place and look at the draft legislation. It is subject to change, of course. And the second one would be related, that when you have your policy in place, make sure you reserve the right to review the arrangement, because business needs will change and you need to keep as much control as you can of it.
Jessica, thank you. Jared, thank you. Sinead and the events team, thank you again. Just a reminder that our Survey Monkey is about to come up, and I hope we'll see you all again soon in person and/or